Welcome to our presentation on the purpose of estate planning. You can reduce its purpose to one word: control. Let's say you're listening to this because you have no written estate plan, no will, no living trust, no power of attorney for property management, no advance health care directive. The truth is, you do have an estate plan. It's just that you haven't written it. Your state legislators have. You may have given control over crucial decisions about your estate to the government. If, for example, you die without a will in California, the fancy term for that is dying intestate, the state of California provides you with a will. The probate court where you reside will distribute what you have following a logical but impersonal formula. For example, if you're married with children, they may transfer some of what you own to your surviving spouse and some to your children. Yes, even if your children are minors, some of your separate property may be split between your spouse and a trust or account for your minor children. And those children could get their share outright when they turn 18. If you are single and without children, the state will distribute your assets to your parents. If your parents are deceased, the court will send your assets out to your brothers and sisters. If you have no brothers and sisters, they will look for cousins or other relatives. This is what is known as intestate succession. I am not going to waste your time talking in detail about intestate succession and the impersonal formula it applies. I am assuming that you wouldn't be listening to this if you didn't want to have at least a written will. If you have a will or intend to write one, you need to understand what probate is. Some people think that having a will avoids probate. You are not avoiding probate by writing a will. The best way to think of a will is as a letter to the probate court telling them what you want them to do, and asking them to make sure the correct assets are going to the correct persons or causes. In California, if your probate assets total at least $100,000 in value, your estate will go through probate sooner or later. Assuming your will is up to date and in tune with the law, the court will make sure your wishes are honored. In contrast with dying intestate, you are in control. You, and not the court, determines who gets what, who is executor of your estate, who is guardian of your minor children, and who manages their assets. Now, if you're married when you die and you have an up-to-date will, the property that's going outright to your surviving spouse need not go through probate. It may be transferred by affidavit or by spousal property petition. The probate process kicks in when the surviving spouse dies. So what we are talking about in this presentation is the probate process when a surviving spouse or a single person dies with a will. What is probate? Probate comes from the Latin word probare, to prove. Chaos would reign if people came into court saying, "John has died. Here's his will. I'm John's only living relative. Please give John's stuff to me." The judge is going to say, "Wait a minute, how do I know that's the last will he wrote? How do I know what John owned? How do I know John wasn't up to his neck in debt and that all his stuff should go to his creditors? How do I know you're John's only living relative? How do I know John died? Prove all this to me." That's probate. Proving to the court that your will is valid and the people and causes you've mentioned and property you've described are correctly identified. If you have a will, you need to understand what property is subject to probate and what is not. You also need to understand the difference between joint and separate property. Let's take these terms one at a time. What property of yours is subject to probate, or as attorneys say, a probate asset? A probate asset is anything you own that does not have an automatic way of going to someone else when you die. For example, that life insurance policy you've been paying into is not subject to probate. Why? Because the policy itself is a legally recognized document that states clearly that the insurance company must transfer the insurance proceeds to the beneficiaries you have named. The probate court doesn't have to get involved. The same is true of your retirement plan. The custodian of your IRA, for example, is obliged to follow the terms of your IRA agreement. The custodian must transfer whatever is left in your IRA to the beneficiaries named. The transfer will take place without court intervention, that is, without probate. The same is true of a home you own in joint tenancy. Joint tenancy makes sure that when one of the joint tenants dies, the surviving joint tenant or joint tenants gets the decedent's share automatically and without probate. The joint tenants are listed right on your deed, assuming you hold property that way. Same with bank accounts, investment accounts, or anything else you own as a joint tenant. They don't have to go through probate. Finally, pay-on-death accounts, POD accounts they're called, transfer assets without probate to whomever you've named on the account to receive them upon your death. To determine whether you have a probate asset, just ask, what document controls the transfer? With insurance, it's the insurance policy. With retirement plans, it's the retirement plan. With real estate, it's a deed that states the property is held in joint tenancy. This is why a good estate planning attorney will make sure you don't try to override any of these controlling documents by trying to use a will to transfer, for example, retirement funds to someone not named on your retirement account. It's the attorney's job to make sure these various transfer instruments do not contradict one another. So again, what is a probate asset? It's everything that is in your name only and that doesn't have an automatic way of passing to someone else. Some typical examples are cars, furniture, bank accounts, and real estate held by you alone, your artwork, jewelry, and other things you own, but whose transfer to others is not backed by a legally enforceable document. Another common probate asset is separate property. What is separate property? An inheritance or gift that comes to you alone is your separate property, whether you're married or not. That inheritance or gift is a probate asset unless you transfer it to joint tenancy or community property or mingle it with your spouse's assets. Also, the wealth you've accumulated before you married is your separate property. Unless you've done something to trigger a transfer now or in the future, your separate property does not have an automatic way of passing to others, so the court has to see to its distribution if you die without a will or a living trust. In summary, you don't want to die intestate, because even though the state is doing its best to carry out your wishes, it's flying in the dark. It's making its best guess. What are the odds that the impersonal state formula will reflect your wishes exactly? Well, if you want to leave something to a good cause, the odds are 0. Charitable bequests are not part of the state formula. Also, do you really want the state to decide who will administer your estate, who will be guardians of your minor children, who will manage your minor children's assets? What are the odds that the state's decisions will match your wishes? This brings us to the purpose of having a formal written plan. You want to have a written estate plan, not simply to have an orderly distribution of your assets at death. The state's impersonal formula may or may not match your wishes, but it will probably be orderly. The probate process will grind steadily forward, but you will not be in control. All you have to do is write a will, and you have regained control over the probate process. More than half of U.S. adult citizens don't bother, a stunning contradiction in a country that so admires individual initiative and responsible action. The reason to have an estate plan is to gain control, both of the distribution of your assets and the care of your minor children upon your death. In our next session, we'll talk more about what is this thing called probate and the pros and cons of probate. See you then.